And it is significant that quite a number of TDs have ignored their slots for speaking. I'll leave it at that.
Public officials or family members, absolutely, with no element of power in their grasp. And then many pregnancies arose from incest, statutory rape or other exploitative situations. And I think that that's what we have to accept. We have to accept that a huge amount of women were absolutely powerless. All did nothing wrong. Many found themselves in exploitative situations because of the huge power differential that was in society, and the great and good at best did nothing to improve that set of circumstances. And we are looking to address this. And I think it's fair to say that the idea of removing those people who were less than 6 months resident in these homes just doesn't wash. We all accept that that these people went through a huge level of pain. That's before we start talking about the failures in relation by the pharmaceutical companies and the clergy. But Minister, you have the power to deliver what is a small modicum of justice for these people who have been too long without it. And I think we all need you to do that.
Thanks. Deputy Catherine Conley.
And it is significant that quite a number of TDs have ignored their slots for speaking. I'll leave it at that in relation to such an important topic. You say in your speech, Minister, the scheme will recognise the time spent and the harsh conditions, emotional abuse and other forms of mistreatment, stigma and trauma experienced by people while resident in a county, a mother and baby or county home. What's missing there is some people, some people. And it'll recognise some damage, and it'll recognise some institutions, and it will give some money. And it's very important, because let's look at the context of how we're speaking, and I'm glad I have an extra time in the slot that I have to elaborate a little bit on this. Let's see where we've come from today. I think it was 2012, which is 10 years ago, that Catherine Corless, local human rights activist and historian, started into her old family tree and then began to discover different things, and we're extremely grateful to her. That's 10 years ago, I think, if my sums are right, and I'll come back to her. Prior to that, we had many indications from many different places that something was very wrong. I come from a city of institutions. I come from Galway City. We had the Magdalen Laundry within a stone's throw of my house. We had the Lenabye Industrial School for Girls. We had the Industrial School for Boys in St. Joseph's, brothers and sisters. I'm aware of that personally. Sisters here, brothers here, never to see each other again, within less than a half a mile from each other. Then we go out to Connemara and we had Lenabye Industrial School for Boys, and in Clifton we had the Industrial School for Girls. I haven't touched the mother and baby home in Tuam, in Loughrea, a city and a county of institutions all over the country. And what was that, Minister? It was part of the architecture of containment, the phrase used so eloquently by Professor Smith from Boston University, as I understand it, the architecture of containment. And we're now 100 years. The last day I read out in recognition of our first constitution, and 100 years later we're looking back at a century of containment, mostly of women, but also boys and girls and men. Every institution was full. For what purpose? For a so-called morality. And various people in society functioned as morality police. We talk about Iran today. I have a great understanding of the morality police, because that's what we had in Ireland when it came to women, done very subtly. So we knew from the 1997 banished babies, we knew from the work of Mary Raftery, we knew work from so many people, most of all ye, and not you personally, but the departments knew, because they have the key to all of the data that's there, that tells the story. And so, into this then comes Catherine Corless, courageous, determined, fearless, and she goes forward and identifies what the inappropriate burials of 798 children in Tuam. And what does she face? let's look at what she faces. She tries, and she tries. And the response from the nuns, and I've read this out before actually, through Terry Prone, and she talks about the letter she got in relation to the well, let me just be specific. Catherine Corliss published her article, The Home, in the Journal of the Old Tuam Society, 2012, detailing the very poor conditions and so on. Not much attention was paid to that. Then she goes forward, and between 2011 and 13, at her own expense, she gets 798 death records. Denise McNamara in the Connacht Tribune publishes an article on the 13th of February 2014 entitled Campaign to Recognise 800 Dead Babies. Were it not for the tenacity of a housewife who has spent 10 years researching her own family tree, the names of 798 children buried in an unmarked grave would be lost for eternity. And of course then we had the Irish Daily Mail, mass septic tank, grave containing up to 800 babies and so on. What was the response of the nuns at that point? Terry Prone, who was speaking for them, to a person who was making a documentary. What did Terry Prone say on behalf of the Bon Secours sisters? Your letter was sent to me by the Provincial of the Irish Bon Secours congregation with instructions that I should help you. I'm not sure how I can. Let me explain, she said. When the Oh My God mass grave in the west of Ireland broke in an English paper, the Mail, it surprised the hell out of everyone, not least the sisters of Bon Secours in Ireland, none of whom had ever worked in Tuam, and most of all, none whom had heard of it. If you come here, you'll find no mass grave. Listen to this now. If you come here, you'll find no mass grave, no evidence that children were ever so buried, and a local police force casting their eyes to heaven and saying, yeah, a few bones were found, but this was an area where famine victims were buried. Now, I read that particularly to set the scene of what Catherine Corliss and what the survivors were facing at that point. And then, of course, we had international attention. And eventually we get Enda Kenny. And finally, the Commission of Inquiry is set up in February 15. And it's set up with limited terms of reference, I might say. It was established on the 20th of February. Interestingly then, there were seven interim reports. One of them, which wasn't published until the final report was published, with no explanation ever as to why it wasn't published. That was interesting and significant as well. Then we have the report submitted to the Minister in the 30th of October 2020, but doesn't see the light of day. Then it's published on the 12th of January with extensive coverage in a Sunday paper. A leak. And part of that leak included comments from the Taoiseach. Can you imagine that now when trust was of the essence? No survivor had a copy. Then we had a webinar and repeatedly told they had copies, no copies. And they were to download a 3,000-page document. Then there was to be a report into the leak that we never heard of, that never came to fruition. Different TDs asked questions and we were told, like water, the leak had broadened out, to hear nothing. Then we got all of the reports. The fifth one is particularly significant in relation to the fifth interim report, because when you come back to the Commission of Investigation, where the caveat was put in relation to the survivors' testimony that it was contaminated, do you remember that caveat? The 550 courageous people who came forward with a caveat from the three wise people from the Commission of Investigation telling us, oh, beware here, beware, this evidence is contaminated or may be contaminated. Look what they say about. Let me just read out here in their fifth interim report what they say about, I'll just get it now, let me, for the moment while I have the time, page 8, and this is repeated. The Congregation of the Sacred Heart of Jesus and Mary, who owned and ran 3 institutions, provided the Commission with an affidavit about burials generally and specifically about Castle Pollard and Sean Ross child burials, but very little evidence provided to support the statements. The affidavit was, in many respects, speculative, inaccurate and misleading. That's repeated again on page 22. That's the Commission telling us speculative, inaccurate and misleading. I didn't see that repeated anywhere in the final report. You might correct me if it was. And of course they raise Hume and Bessborough distinguished themselves by having no records in relation to the burials, and the Commission do rise to pose the question. The more difficult question to answer is why the children were buried in such an inappropriate manner. And of course they go through whether the chambers were used for sewage or not, and they feel obliged to clarify that they weren't. However, not highlighting the fact that there were sewage chambers where the bodies were wrapped and placed. And they point out that a concrete lid had to be lifted so that those baby bodies could be put down and so on. Now, I don't know if you've read these reports, but they're there in black and white, and you say speculative, inaccurate and misleading. There's no caveat in the final report in relation to their evidence. Instead of that, a premium is put on the accuracy of their evidence. There's also a little on the sale of bodies. The sale of bodies to the medical students or the medical department in Galway, and they give the price for which the bodies were sold and how the porter sold them and the doctors received them. Worth looking at, really. But I'll stay focused in relation to what we're doing today, and you tell us this is human rights. This has nothing to do with human rights. This has to do with a cold, calculated decision in relation to costs. That's what this is about. I'm not going to waste my time to say that you've done a good job and I believe in your bona fides, because at this point we now have a very faulty bill before us based on cost containment, not on justice. And I find it insulting to be told that it's based on human rights principles. I find it absolutely insulting. It's probably my last time to have such time to talk about it, because I'm going to be absolutely blunt in my comments in relation to this, not on my behalf, but on behalf of Catherine Corliss, on behalf of all the brave people who have stood and tried to educate us TDs, who have taken cases to the court, who succeeded in getting an annex or another document appended to the Commission of Investigation report, setting it out they had to go to court. 2 or 3, and then in the background, more courageous women waiting to see it, and then there's a settlement, isn't there? And that's what's in the library now. Very courageous people coming forward, the Clon people, Mairead Enright and her colleagues. I could name them all out, Katrina Crowe. All helped to educate us TDs, as well as our own gut feeling and our own work. To come forward to say, this is the time, Minister, to get it right. To make language mean something, because language has meant nothing. There was no forced incarceration, no. There was no illegal adoptions. There was no evidence of the mothers of their consent not being taken. Imagine this is what's been said. And we listened to 550 people, and then we don't take on board what they said. Then we have the whole debacle on top of the leak in relation to the recording. You can shake your head, or you can listen, and you can learn, like we all can, because I'm no expert. But I'm certainly an expert in having read the stuff and made myself aware of what we're being told and what people have suffered. I would say I'm an expert on that at this point, only on that part. In everything else, I'm no expert. So we had the leak, and then we had the whole debacle of the recorded material that wasn't recorded, that was recorded, and all of that. And then we come forward to this bill, and we leave out how many people. We put the emphasis on the inclusion of approximately 34,000 people, with 19,000 qualifying for an enhanced medical card, for which I'm sure they should be very grateful, really. The number who spent longer than 6 months is 14,507. The number that spent less than 6 months is 24,149. So we have excluded the vast majority of children who were in mother and baby homes on spurious grounds that they were a tabula rasa, nothing affected them, and at the end of 6 months they were still a tabula rasa. You've done this despite the fact that the Irish Human Rights and Equality Commission has set out that this is wrong. The Irish Council for Civil Liberties, 34 clinicians working in the area of childhood trauma. Simply not based on scientific evidence, not based on our experience as mothers and fathers. You've excluded all of those children. And you talk in another speech how you cannot monetize the harm done. That's exactly what you have done. That's exactly what you're standing over, the monetization of suffering in the most narrow way possible. And then you've excluded children who are boarded out. We're going to ignore them as well, even though the interdepartmental group looked at the number there, 4,757. All of these numbers are very specific, and they're easy to deal with in a sense for a proper, just, fair redress scheme based on human rights. You've ignored the people who were illegally adopted. Do you remember the Marion Reynolds report that was never discussed in the Dáil? The woman who asked for her name to be taken off the report, as I understand it. If I'm wrong, I've asked you repeatedly to correct me. I understand that that author asked for her name to be removed from the report because of changes made by you and your department. That was a scoping exercise to see the extent of the illegal adoptions, never been dealt with. There is no redress for systematic racism, despite UN human rights experts highlighting this in correspondence, and you know this as recently as the 23rd of September. It's discriminatory, it doesn't include all relevant institutions. Remember, the Commission of Investigation chose a sample number of county homes, and then the major mother and baby homes, not all homes, and you're proceeding with that, although there is the option there to include. You're completely ignoring the bonding, as I've said already, and I just want to refer to an email. I'm not going to say it, although I have been given permission, but I won't. But just to give an example, 3 children, 3 siblings, 2 were adopted at 9 months, so they will come under the scheme. A 3rd sister, who was born a few years later, spent less than 9 months, will not come in. Imagine that family trying to explain this to each other. The 2 that were adopted at 9 months will come under the scheme. The 3rd sister, who got out before 6 months, will not come under the scheme. Just to place it in reality. Your work-related payments, it didn't work. It was forced labour. You know that. I know that. So what I find from all the submissions from the human rights, survivors groups and organisations is, for the first time, let's place human rights at the heart of this legislation. They asked for 4 basic principles of human rights to be enshrined so that the redress is in context. I looked at the title. It does not enshrine the basic principles of human rights, which I don't have time to go into, but they've already been read out by Deputy Sherlock in relation to the Irish Council for Civil Liberties. So, why am I saying all of this? Because we've had the Redress Board in 2000, every 10 years actually, as it turns out. In 2003, the institution's Redress Board, where you had a waiver and you committed an offence, me included as a barrister at the time, if I disclose anything about the ward, that criminal offence is still there. Fast forward then to 2013, the Magdalene Redress Scheme. Remember the Ombudsman's report? We should learn from it. You know, what did he say? Basically, to learn from it. In order that he talked about the maladministration, do you remember those words? In order to ensure that any future restorative justice or redress schemes benefit from the learning, from the operation of this and other schemes, there must be guidance. Those documents must be open and accountable and be there. Nothing, absolutely nothing. Then I was at the redress scheme in 2003. I moved forward to the Magdalene in 2013, and this scheme probably will come operational in 2023. So every 10 years in that 30-year span. That's 30 years I'm taking out of a 100-year span, Minister. And what have we learned? We're still persistent with the waiver, aren't we? Now, I pay tribute to you. You've removed the silence in relation to the amount of money they're going to get, which is progress. Can you imagine that? 20 years later, to take that out, but you're still saying the waiver, in spite of the fact that the UN Committee Against Torture found that the waivers imposed upon Elizabeth Coppin in the Residential Institution Redress Board and the Magdalene ex gratia restorative scheme were unenforceable. They affirmed that the state is required and so on. I haven't time. Worth looking at that. You're keeping the waiver. We've received to STDs numerous emails. One in particular, St. Maurice, Fannin, Lifford. why it wasn't included in the scheme, and I'm sure we're going to get many, many more. As I said, Board It Out has been ignored, and the waiver has been ignored. Finally, in my last minute and a half, you're setting up a body, haven't learned nothing from Carranua and the debacle that was, and the misnaming of it as a new friend, and you're setting up another office within your office, not independent. No idea as to how the application will be made, oral, affidavit, a story. There will be a review, which I welcome. The review will be carried out by the deciding officer. Then there will be an appeal. And you know what? The appeal is heard, and then just to make sure that the person has no sense of the independence, the deciding officer gets to tell the person what the result of the appeal was. Can you imagine that? For lack of, I don't know, insight. Then we have no up-to-date on the negotiations with the religious orders, and we have no update on relation to the pharmaceutical companies. Finally, two things. The legal aid that you're giving is minimalist in relation to two aspects. One, the waiver, and two, in relation to an affidavit. That affidavit arises where the chief deciding officer is unhappy with documentation and he needs an affidavit. The question also on the documentation, the chief deciding officer has access to the archives to make a decision. When he gets those documentation, will he make those available to the applicants? Because that would be absolutely essential if justice was to be done. Finally, outstanding correspondence with your department. For over a year to 2 years now, I've been asking for all of the documentation between the government, your department, and the Commission of Investigation. I tried to work with your department and narrow down the scope of it, and I have still no reply.